morning, and thank you for joining us. My name is Kelly LeGrand Wiener, and I'm the managing attorney at Scott Legal. We're going to spend some time today talking about the National Interest Waiver Green Card, also known as the NIW. This is an underutilized category and one that we've started to see more and more people use to actually get a green card, in particular in the entrepreneur category. A few things to go over before we get started. Scott Legal is a full service immigration firm, but we offer a number of different services for different types of visas, including visas in the NIW category. We will continue doing our webinar series with at least 2 webinars a month on different visa topics. At the end of this webinar, we'll send out a few things to you. One is this PowerPoint that you'll see today. Another is a comprehensive guide on the National Interest Waiver, and also a link to where you can sign up for additional webinars. For our panelists today, as I mentioned, my name is Kelly LeGrand Wiener, and I'm the managing attorney at Scott Legal and regularly process NIW visas. We're also very lucky to have an associate at our firm, G.A. Wang, who is an NIW expert and has vast experience in this area. If you have questions as we go through the presentation, please send your questions, either through the chat box or the question box, and we will try to, make time for them, either if it's relevant to what we're going over, perhaps when we're doing the presentation, but if we're not able to get to it, we'll get to it at the end of the presentation. Finally, this webinar will be recorded and made available on demand. So we will get started with just talking a bit about the National Interest Waiver requirements. So the National Interest Waiver is something that's it's a green card category. So it's for people who want to reside in the United States, live here on a green card. And there's 2 threshold requirements that you have to look at. So you need to meet one of these threshold requirements. So in the EB2 category, you must have either an advanced degree, which means a master's degree or higher, or its equivalent, meaning a bachelor's degree plus 5 years of post-baccalaureate progressive work experience. Or if you don't meet that criteria, you can also qualify for an EB2 through something called exceptional ability. Exceptional ability, you're going to look at a 2-part test to determine if you met this criteria. So the first is, did you objectively meet the criteria? And the second is, from a final merits determination, holistically, does the evidence show that your expertise rises to the level of exceptional ability? So you must meet at least 3 of 7 criteria to qualify for exceptional ability, and those criteria are listed here. I won't read them all out to you, but when you have the webinar or the PowerPoint that's sent to you, you can kind of take a closer look at them. But there are several kind of different criteria that you can use to show that you have exceptional ability in your particular area. Exceptional ability, oftentimes it can be confused with extraordinary ability, which is another, term that's used in the immigration field for certain types of visas, like the O1 or the EB1 green card. Exceptional ability is different in that it's defined as a degree of expertise significantly above that ordinarily encountered in the sciences, arts, or business. In contrast, extraordinary ability means a level of expertise indicating that the person is one of a small percentage who've risen to the very top of their field in the endeavor. So exceptional ability is a lower standard than extraordinary ability and a bit easier to meet. However, both of them go through that same 2-part test, where first you have to show that you actually just meet the regulatory criteria, and then they're going to look at the quality of the evidence. So for example, being a member of a professional association would satisfy just the plain language of the criteria. But in that second part of the analysis, they're going to consider whether the membership indicates the person has a degree of expertise significantly above that ordinarily encountered. So if it's a type of membership where you just pay a fee and anyone can join, that's really not going to be good for exceptional ability. If it's the type of thing where you have to be, there's an application process, or you have to show prestigious accomplishments in your field, to join, those are the types of things that are helpful to prove exceptional ability. So once you have, met that threshold requirement of either the advanced degree or exceptional ability, then we look at the actual national interest waiver criteria. So under a normal EB-2 process, you have to go through something called the PERM process, where you have to have an employer. They have to test the labor market to prove there are no willing, qualified, and available U.S. workers. When you're doing a national interest waiver, what you're saying to the government is, please waive that requirement of the employer job offer and the national and the labor market test. And the way that you qualify for that is you show that you are engaging in an endeavor that has substantial merit and national importance, that you as the applicant are well positioned to advance that endeavor, and then on balance that it would be beneficial to the United States to waive the requirements of the job offer and thus the labor certification. So, thinking about an example of a national interest waiver applicant who met these criteria, and we'll go over, GA will go over for us in much more detail later, a very specific example, but just to run a quick example by you in the beginning. One example is an engineer who was going to, their proposed endeavor was to run a consulting firm in the area of technology management and workplace consulting. This person had developed a patent to help small and mid-sized businesses automate and optimize profitability without losing any jobs. So kind of an ability to retrain and redefine your workforce to prevent U.S. job loss. So when we look at each of these prongs, substantial merit and national importance, preventing U.S. job loss, providing U.S. companies with a way to stay technologically, at the forefront and competitive, while also not displacing U.S. workers. Additionally, we argued that hiring U.S. workers was part of that, substantial merit and national importance. So in that particular area, there was lots of kind of media and articles about kind of how technology advancement and automation may lead to job loss. So this was a really relevant area, something there where there was lots of different kind of industry reports, major media articles about it that could be brought forth to help argue that it had both substantial merit and national importance. In terms of the prong of being well positioned to advance the proposed endeavor, this applicant had, about 35 years of experience in relevant jobs, was able to get letters from former supervisors, former colleagues, as well as experts within relevant industries who were interested in partnering with this business to use the information and patent in their own business. So then on the third prong of being on balance, it being beneficial to the U.S. to waive the requirements of the labor certification. On one hand, for entrepreneurs, you can argue that it's impractical to go the labor certification route because entrepreneurs, owners of companies, are generally just not eligible through the PERM process because they have the ownership of the company. It's just the PERM process is not going to work for them from a practical perspective. You can also argue that having someone who's experienced in this area working on this issue, this really important issue of preventing job loss and worker displacement, is beneficial to the U.S., even if there are other qualified workers performing similar work. Additionally, you can argue that the contributions to the economy and the retention of workforce in U.S. companies, particularly small and mid-sized companies, is urgent enough to warrant foregoing the labor certification. So these are all kind of different arguments you can bring to bear, when you're looking at the national interest waiver requirements. So looking at how specifically can the national interest waiver be used for entrepreneurs? It used to be that the national interest waiver, was very often entrepreneurs are not the first category of applicants you think of when you think of national interest waiver. However, back a few years, there was a change basically in the standard of adjudicating national interest waivers that made it much friendlier to entrepreneurs, and both this change and government action since then have indicated that the government does intend that national interest waivers are used for entrepreneur applicants. So certain things that were extremely helpful when they changed the standard for entrepreneurs, one was that you can, the case laid out that the benefit to the U.S. interest can be local. So hiring employees in one local area can be used to help satisfy the substantial merit and national importance prong. Before there was kind of a focus on, oh, well, whatever I'm doing has to have this large geographic scope. So in the Danazar court, in the new test they laid out, they specifically said that they moved away from that focus. So obviously it's helpful if you do have that focus, but you don't have to have it as long as you can still argue national importance. So hiring lots of employees in an area with significantly, an economically depressed area is going to, could potentially satisfy that standard of national importance, even if your endeavor is not kind of having a nationwide impact. Another, thing that was mentioned is that entrepreneurs as self-employed, individuals are often just not eligible for green cards under, the labor certification process. So the fact that it is impractical or really impossible to obtain a green card through the normal labor certification process as an owner of a company does help to show that on balance, it's beneficial to waive this requirement because the requirement doesn't make sense in the context of the person's application. I think someone raised their hand. If you do have a question, if you could just type it through the chat box or the Q&A, and we'll get to that, towards the end. And then finally, DNSR does specifically note that entrepreneurial work can lead to a national interest waiver. And importantly, they state that the planned venture doesn't have to ultimately succeed as long as the applicant can show it's more likely than not to succeed. So this, I think, was really kind of opening the door for more startups. Obviously, I think it's very helpful and important to show that you're well positioned by showing you've had previous success in a particular industry, but it's to say you don't have to come with an already successful venture to qualify for the NIW. You could come with, more of a plan for the future, a comprehensive plan. And we'll talk a bit more about what documents could help support that. And they acknowledge that entrepreneurial undertakings can be risky. They do not always succeed. But if you can show a track record of success in your history as an entrepreneur, that can be really helpful if you're coming with, more of a startup. Something that, entrepreneurs will often ask us is it better to apply with an established company, or with a startup? So, it's possible to apply with a brand new startup. Applying with an established company is helpful if the company has, a track record of success, track record of job creation. If you've been running the company and the company is not doing very well, that may be a harder case even than a startup, because now you have to work against kind of the negative, perception of what's been happening with the company so far and explain how you're going to get back on track. Versus if you have a pure startup, if you have an idea, then you have that ability to submit a comprehensive business plan, with financial projections and hiring projections. And if in the past you've been able to bring a business plan like that to fruition successfully, then that would be, possibly better even than going in with a company that you've been running for a while that's kind of not doing that well. So sometimes a startup may even be better than an established company. So let's talk a little bit about just kind of timing and considerations when you're moving from a non-immigrant visa to a national interest waiver green card. I think that, many of our clients are kind of already here on other, long-term visas. Perhaps they're here on an E2 investor visa. And so they want to, or maybe they're on an O1 extraordinary ability visa. They want to kind of figure out, like, how do I transition? Other people are, not here long-term. Maybe they've come in and out, on B1 business visitor visas or on ESTA. So in terms of timing, at this point, there is no premium processing available for the national interest waiver if you're filing today. So if you are filing a brand new national interest waiver petition today, there's no premium processing available for you. So that means your I-140 petition could be processing for several months, even up to and over a year. There is a caveat here, which is that national interest waiver premium processing has become available for certain petitions that were filed, in the past, I believe, in 2021 or earlier. So the, if, like, for people that maybe if you're here and you've already had your petition pending for a long time, it's worth checking the exact dates, because there may be an ability to premium process. And that would mean paying the government $2,500 to get an answer within, I believe it's 15 calendar days. I'm not sure if they changed the days for the national interest waiver.
I think it's a little
GA,
longer. Yeah, I think it's a little
mhm.
longer for the national interest waiver. So I think it was 3 months actually.
Right, right.
Yeah,
Yeah, I think they made that a bit. So it's
longer.
something to consider only if you have a national interest waiver petition already pending. Um, so if you don't, then you're going to be basically you're going to be waiting for several months or up to a year. However, they have kind of continued to say they're going to make premium processing available for the national interest waiver, generally. So that's something to keep an eye on. Eventually that may be available. So if you have an underlying visa status, but you're here on a non-immigrant visa that doesn't really allow for dual intent, so that's like a TN visa, an E visa. Once you file your I-140, it's going to be potentially difficult to renew your underlying visa. So if you have a TN visa, there's a very strong, requirement to have a residence abroad you don't intend to abandon. So if you are here on a TN visa and you want to file an I-140, you want to think strategically about when you file that. So you can get a TN potentially for 3 years if you're Canadian, or 1-year visa stamp if you're, from Mexico. So you would want to kind of think about renewing your visa, getting as much time as possible before filing that I-140, just knowing that, it may be difficult to renew once it's filed, and you want to give yourself as long as possible, on that underlying status while it's pending. In terms of the actual application process for the NIW, it involves submitting an I-140 petition with all the proof that you meet the EB2 qualifications. So that's, what we had just talked about, all of the proof that you meet the threshold requirements. So your degree and your transcripts, or proof of your exceptional ability. And then you would also submit all the proof of the national interest waiver prongs. So substantial merit and national importance, proof that you're well positioned to advance the endeavor, and proof that on balance, it's beneficial to waive the requirements of the labor certification for you. Depending on what status you're on, you may, and if there's an immigrant visa available to you in the EB2 category, then you may be able to concurrently file an I-485 green card petition. So let's say you're here in the US, and you feel very confident about the strength of your petition, you could file the I-140 and the I-485 green card petition together. Along with those applications, you can file for work and travel authorization. But if you do that, you have to know that you have to stay in the US for, until you get that travel authorization granted. If you file the I-485 and you depart the United States, you will have abandoned your green card application if you do it before you get the advanced parole. There is limited exceptions if you're on an H or L visa, so that's worth kind of discussing, with your immigration attorney in terms of travel. But once you file that I-485, you just want to know that you don't want to travel until you really speak to your immigration attorney to figure out, okay, am I on an H or L and can I travel under this particular circumstance, or should I wait till I get my advanced parole approved? So that's something to consider as well. And if you are here let's say you're here on a TN, and you file your I-485, you get your advanced parole, when you travel, you just know you're no longer on a TN. Like now you're in a period of authorized stay while you're waiting for your green card. So depending on your particular situation, it might be best to preserve your underlying status for as long as possible. That gives you options in case your green card application is ultimately denied. But it's just something to consider in terms of what are your goals? Do you need to travel internationally? If you are someone that needs to travel internationally frequently, or you don't live in the United States, or not here on a visa that you can stay long term, then you can file the I-140 and then you would go for consular processing after the I-140 was approved. So the filing of the I-140 actually doesn't give you any status in the United States. There's no ability to stay in the US just based on the filing of the I-140. It's just a petition that's going to pen for a long time. The only thing that gives you the ability to stay is if you can currently file the I-485 or if you have an underlying visa status. So that's just important to note that if you were, let's say you came in on an ESTA, and you filed an I-140, you cannot stay past the date of your I-94 expiration. The I-140 filing, does not provide any status. If you're going to consular process abroad, then generally what will happen is after your I-140 is approved, that approval will be sent to the National Visa Center. The National Visa Center will collect, biographic documents from you, documents, to prove that you're eligible and admissible to the United States. And then they'll send that to the consulate abroad where you reside. You'll attend the interview. And then when you enter the United States with your immigrant visa, your green card will be mailed to you within a few months after entry. So in terms of pros and cons of adjusting status versus consular processing, it really is specific to the applicant. It depends on their goals. So, as I mentioned, if you were living here long term, with your whole family is here, your life primarily is in the United States, then adjusting status is probably going to be the right move for you. If you're someone who's living abroad, or you're someone that needs to travel internationally all the time, like you'll never be able to just, stay in the US for 6 or 7 months while you're waiting for your travel authorization, then consular processing might be, the correct route for you to take. Something that, people often ask is, can your family members, also apply? And the answer is yes. Your spouse and any children under 21 can also apply as part of your green card application. So let's turn to GA to talk about what is included in an NIW submission.
Great. Thank you, Kelly. So yeah, let's look at what is typically included in an NIW submission. And it is important to note that the NIW petition is a very paper-heavy application. So a good way to think about this is that all of the arguments that you make, the government will not simply take your word for it. The more objective proof about the impact of your work, the prospective impacts, the better and stronger your petition will be. For example, if your work has been featured in the media, that can be one example of a third-party report talking about your work and the importance of your work, and you would want to include all of these media articles as evidence of the importance of your endeavor. Okay, so when preparing an NIW petition, the first thing you want to do is provide evidence that you meet the EB2 category threshold. So for example, if you are qualifying for the EB2 threshold based on holding an advanced degree, you would want to submit the diploma and transcript from your academic institution for the master's degree, for example. And if your master's degree was from a foreign institute, you would also need to submit a degree equivalency report that shows that your degree from that foreign institute is equivalent to a master's degree from a US institution. If you are meeting the threshold of advanced degree through a bachelor's level degree and progressive 5 years of work experience, just including your resume would not be enough. You do need to get letters of confirmation from your previous employers to demonstrate that you do have 5 years of work experience. And by progressive, I mean taking on more senior duties as time goes on. So those letters would need to be detailed in a way that shows that your duties have changed over time. If you are meeting the threshold through the exceptional ability prong, then you would want to provide proof that you first do meet 3 out of the required 7 criteria. So for example, one of the criteria is if somebody has 10 years of experience in that field. You would want to show that through employment confirmation letters from your prior employers as well. If you are arguing that you're meeting the criteria for memberships in a professional association in your field, you would want to submit documentation of these memberships through certification from the relevant authority, certifying that you are a member and that you are in good standing. Also, you would want to submit evidence of the selection criteria on how you would earn membership in those associations, so that the government knows how you get selected to be a member. If it is through a payment of a fee, for example, we have mentioned that it is not a great, not very helpful towards proving exceptional ability. But if it is based on a selection through evaluation by a jury of members, for example. That is certainly very helpful. All right. So if you are also submitting a relevant degree, even if it's not an advanced degree, sometimes you could submit your diploma or associate's degree to meet the 3 out of 7 criteria for exceptional ability. So you would want to provide copies of those degrees as well to prove that you do meet that criteria. So now that you have established that you meet the EB2 category threshold, the next part of the petition will be collecting evidence supporting the 3 prongs of the matter of Danazar test for qualifying for an NIW. So for example, first, you would want to submit a detailed statement of your proposed endeavor. It is very important to prepare a proposed endeavor that outlines exactly what you will be doing through your business if you're an entrepreneur, and include in that description, if you're developing any new technology in your field, you should explain how this will improve upon how things are normally done in the field. This will go towards describing that the impact of your work will not only benefit the direct customers or clients that you work with, but will introduce advances to the entire field that could rise to the level of national importance. And so, in addition to providing a detailed statement of your proposed endeavor, to support national importance, you would want to research and include evidence that the public or the government is interested in the area that you will be working in. So, for example, sustainable agriculture, improving healthcare, high tech, data processing, semiconductor industries, or cybersecurity. Those fields are areas of high interest for the government, and to evidence this, you would want to include news articles, journals, statistics, government reports, market reports, and expert letters from experts in the industry who would talk about those fields and why they are of critical importance to U.S. national interest. So, for example, if you're an entrepreneur and you are developing new technology towards sustainability, let's say if you are developing a way to reduce emissions in cars, you can include the government's pronouncements related to talking about why it is important to reduce emissions in cars. You can include expert letters that link your specific endeavor to how that government goal will be better advanced. You can even include letters from Congress people if you know any Congress people who are interested in your endeavor. That can also be a very powerful strengthening factor of your application. So one more word about expert letters. So expert letters are very important in an NIW petition, precisely because they can make that link between your endeavor and how your endeavor serves the national interest. So when you submit expert letters, you would want to include a detailed curriculum vitae of each expert that establishes him or her as an authority in that area. That will boost the credibility of that expert's pronouncements in the eyes of the government. So certain pieces of evidence that could be helpful specifically for entrepreneurs. One strategy that an entrepreneur could follow is to include a letter from an economist, and that economist can provide some detailed explanation regarding the prospective economic benefits of running that business. That will include job creation. And for that sort of letter, you would give the economist your business plan and historic financials of your business. And based on those data, the economist would run a software or a formula and be able to project not only the direct economic productivity positive impact of your business, but also the indirect and induced economic benefits, which would likely be substantial. And this would go towards supporting that your proposed endeavor does have the substantial economic positive benefits that could rise to the level of national importance. Now, the government actually updated their guidelines a few months ago on what specific evidences that could help an entrepreneur application. And so some of the things that the government listed as something that could be helpful, some pieces of evidences include letters of interest from investors, future clients, which goes to both national importance and well-positioned. You could also include evidence of prior success of your business by including proof of revenue growth, proof of hiring through tax returns, for example, if you have been running your business for a while. Another type of evidence that could be helpful is copies of intellectual property you have authored or your company holds, and proof of incubator or accelerator admission that could also show the merit of your business, and also press releases and other articles published in media discussing about you or about your proposed entrepreneurial endeavor. So to look at all of this in a holistic way, it is clear that NIW petitions are not cookie cutter petitions. They are usually very structured, very strategic in what evidence that is collected and what evidence we seek to highlight. And organizing these evidences in the most persuasive way is very important, precisely because the NIW is such a paper-heavy application. All right, and now we can move to the next slide, and we can go over a specific case study. All right, so let's look at a case study for which the USCIS originally denied the petition by an entrepreneur who wanted to set up a consulting firm to work on improving services to U.S. veterans. But this case was flipped at the appeals stage at the AAO, and ultimately this application was approved. And the opinion by the AAO is very helpful because it runs through the decision-making processes of the government and gives us a good idea of what sorts of evidence the government is looking for when evaluating an NIW petition. So what this entrepreneur did and proposed to do is noting that returning veterans have a very difficult time and that there is a lack of quality services for returning Iraq and Afghanistan veterans of the U.S. Army, and that improvement of these services is needed for assuring their physical and emotional well-being. And in support of this argument, this petitioner included news articles, research reports that talk about the problems in this area and how more progress is needed. The petitioner also included letters from senior officials in U.S. government agencies, businesses, and philanthropic organizations, which affirm the importance of providing effective programs for U.S. veterans when they return. And the petitioner made clear to make the specific link between these areas of national importance and the petitioner's proposed work through their business, which was to improve programs and assist organizations by providing consulting services that provide support and advocacy for U.S. veterans and wounded warriors. So in all of these evidences, relying on those evidences, the government concluded that there was significant public interest in supporting U.S. veterans' causes, and that the petitioner's work significantly would advance this endeavor, advance these causes. So they concluded that this work had national importance as well as substantial merit. Turning to well-positioned. This particular individual happened to be a veteran himself, and he had firsthand experience in the Army, as well as had worked on a variety of related specific projects before setting up his company. So what was very helpful in this case was providing expert letters from senior officials in related organizations, government organizations, that talked about specific examples of prior successes that this person had led. For example, the letters describe successes in veteran job placement with specific metrics. Another letter talked about how this petitioner managed placing millions of dollars of charitable funding to productive use through connecting with agencies that serve the veteran community, and did a exceptionally superior job in making these linkages between US and UK charitable sectors, and even described, and I quote, "Without him, we would not have made those links." So it is clear that this person played a critical and indispensable role in the success of these projects, and that served as very powerful evidence that he was well positioned to continue working in this field. The petitioner also included a business plan, and in that business plan, the petitioner identified potential clients, specific organizations that he would work with. The petitioner included sales and staffing projections that were specific, and also included a detailed operating budget. In addition, the petitioner included financial statements of his business, which reflected that he had enough startup funding to set up and operate the business. Finally, the petitioner included letters from government agencies saying that they would refer clients to his organization, and also included emails from prospective clients confirming their interest in working with him. So in a holistic consideration of all of these evidences, it was clear to the government that not only did this person's endeavor serve the national interest, the person was also well positioned to advance this endeavor. And being an entrepreneur, on balance, it would be beneficial to waive the onerous requirements of getting a labor certification and job offer requirement, to make sure that this person would be able to stay and work in the US. Okay, so I believe now we can go on to the Q&A section of the presentation. I think we have one question on the chat box so far. Can you choose the location where you file your I-140? And this question has already been answered. No, you cannot. There are specific guidelines on where your petition will be filed. After your I-140 is approved, how to request for consulate consulting in a US embassy abroad. And do I still file I-485 or some other form? Yeah, so after your I-140 is approved, the case will be sent to the NVC, the National Visa Center, and you will get a notification containing the instructions on how to submit a DS-260, that is the online immigrant visa application. And once you do that, you'll be able to set up an interview at the consulate that you apply at, and then you will get an immigrant visa and you'll enter the US after that. Okay. If there are any other questions, please ask them now. If not, I think we are ready to close. Thank you so much, everybody, for participating in the webinar, and I hope this was helpful information for some and all of you. And we are always very happy to jump on a consult if you are interested in pursuing a NIW petition. We will be happy to help. You can look us up in Google, and we also have future webinars coming up, so please stay tuned.
Thank you so much. All right. Thank you, everyone. Thank you, Jay. Have a great day.